Are the proposals in the Defamation Bill sound, and do they go far enough? So I have a summary of the Defamation Bill, and the main purpose of the bill is to reform the law of defamation to ensure that there's a fair balance is struck between the right to freedom of expression and the protection of reputation, which is the whole summary of the bill. I have about a few points that summarizes the whole bill. The first point is that a new requirement is that the statement must cause serious harm and for it to be seen as defamatory. So this is in order to discourage trivial claims. My next point is that it creates a new statutory defence of responsible publication on matters of public interest. So yeah, next one is that the statutory defence of truth and honest opinions to replace the common law defence of justification and fair comment. And one of the other introductions that this bill is going to produce is the single publication rule. And this is to prevent an action being brought in relation to publication of the same material by the same publisher after 1 year limitation period has passed. It addresses libel tourism, and this is to tighten the test applied by the court. And this is in relation to actions brought against people who are not domiciled in the UK or a member of the EU state, EU member of state. It removes the presumption in favour of the jury trial. So this leaves the judge a discretion to order jury trial where it is in interest of justice. A new introduction also that the bill produces is greater protection to secondary publishers like booksellers, and actually I missed one. Yeah, introducing a new process governing responsibility for the publications of the internet, and this gives greater protection to operators of the websites which host user-generated content, and this provides that they comply with a procedure to enable the complaint is resolved for any dispute direct with the author of the material which is concerned. And the secondary publishers one is based on to protect booksellers, so that is taking away the court's jurisdiction to hear an action of defamation brought against them, except to where it is not reasonable practicable for the claimant to bring action against the author, editor, or commercial publisher. And currently the Defamation Bill, it was agreed with the coalition government that they gave a commitment to review the overall bill. So the latest update of the bill is that it has just gone through its third reading in the House of Lords, which was on the 25th of February 2013. And the House of Lords discussed amendments on clauses 2 and 6 of the bill. And so the bill is now going to be returned to the House of Commons for consideration.
Okay, I'm concentrating on the proposals of the Defamation Bill sound. So as it currently stands, the main complaints about our Defamation Act is that it exercises an unacceptable chilling effect, which means people are scared to speak their mind because they're scared that they might get sued. So the bill tries to address this by like introducing a number of proposals. So I'm going to just say what makes the bill sound and what doesn't. As Oyin said, there's now a requirement of serious harm to prevent trivial claims, because before you didn't have to. It just had to be substantial harm, and the harm didn't have to be serious. Like, it had to cause likely harm. So it stops the abuse of the right to sue, because claims for defamation are not always brought with the intention of preserving the claimant's status in the eyes of other people. In some cases, the claimant hasn't suffered any serious harm as a result of these words, but still brings claims with the objective of punishing D for saying negative comments and warning other people not to take similar liberties. So like in the case where the person was called ugly, like did they really suffer serious harm? Like some people might argue they didn't, some people might argue they did, but the requirement of serious harms means that these small claims like, don't keep going through. The bill will pave the way to end libel tourism by providing that a case where the defendant does not live in the EU or British court will not have jurisdiction to hear the claimant's case unless the court is satisfied that all of the places in which the statement complaint has been published, England and Wales is the most appropriate in which to bring this action, because right now it seems like English law is very pro-claimant, so people are bringing their cases to England because they know they're going to win. And the new law tries to address this by saying that if their claim is not central to England and Wales, that it won't be heard. Like, yeah. The bill takes steps to protect website operators who are merely hosting content, like Facebook and Twitter. As the law stands, it encourages them to ignore any dubious material, but then to remove it without any questions following a complaint because of the fear of legal action. And in the Defamation Bill, Clause 5 acts as a defence, which means that if operators are able to show it wasn't them who posted the comment, that they won't be held liable. Like, it goes through whoever posted up the comment. So if you're just hosting, like putting it whatever, you won't get in trouble, which seems kind of fair because it wasn't them who wrote the comment in the first place. Despite its strengths, there are reasons to believe the proposals of the Defamation Bill are not sound. And as I talked about, what's it called again? It ends libel tourism, and that this can also be seen like a downside because the bill's proposals on jurisdiction is to the same standard as the one the courts apply already in determining whether they should decline to hear defamation cases. It's basically similar. So the bill basically says if it's appropriate enough. That's basically what it is at the moment. So cases such as the Berezovsky versus Michael, like the one she talked about, he published it in his magazine in New York, only sold 2,000 copies in England. I'm not sure if that case would have been decided differently with the introduction of the Defamation Bill. The new requirement of substantial effect is likely to add to the cost and complexity of the defamatory trials because it's not straightforward anymore. It's like you have to prove it caused serious harm, so this could make the process more complicated. Clause 5 of the Defamation Bill also provides that for unidentified materials, in order to avoid liability, the operator will need to respond to any notice received in accordance with any provisions contained in regulations. So basically, for materials put up by people who can't be identified, they deal with, like, the hosts of websites have to deal with it in accordance with any provisions contained in regulations, but they haven't actually decided what these regulations are. So they're going to be made by a statutory instrument. So we're not sure what it is, and they're saying that depending on the different circumstances, depending on what way they decide it, so it's not really that fair because, you know, I think the fairest way is just to make sure if a material's unidentified, they should take it down until they have further reason to put back up, instead of going through the regulations that no one knows about and which could be unfair. Another reason why the bill can be seen as not sound is there's difficulties in procedure to have identifiable materials taken down. Government is content at the moment that where an author is identifiable, complaints should pursue remedy with them first before the court. So they're saying, okay, if it's identifiable, go straight to the author before you come to the courts. But this makes it harder because, say, for example, the defamatory comment is made in a video. How are you supposed to publish that on a website that the comment is defamatory? It just makes it a lot harder. Yeah. With the single publication rule, the 1 year might not be a sufficient amount of time for the claimant to bring forth actions due to circumstances. I don't know, 1 year just might not be enough for them. And there's no real justification to remove trial by jury because, yeah, I think jury are like normal people, so like they are fully capable of knowing what right mind thinking people think, and it's just like it's shifting more power to the courts rather than having the jury, you know, do what they do best. I don't think there's any real reason for them to remove trial by jury. All in all, I think the bill, like the proposals such as serious harm, single publication rule, and wide-ranging exemptions of liability will help protect freedom of speech and public opinion. However, genuine claimants who use host websites to resolve their complaints may find effective and affordable action is beyond their reach. They may feel that the balance is not fair and that it has shifted too far in favour of the publishers.
The main criticism seems to be that there's a lack of balance and that it tends to favour the claimant. In terms of going far, it does introduce a serious harm test, and non-natural persons, that's businesses, have to prove that substantial financial loss occurred, and any statement made about a non-natural person about the function to which they perform won't be considered defamatory. So in that extent, it does produce some changes. And also by shifting the balance in favour of the defendant, it does, in a way, protect Article 10 of the European Convention of Human Rights, that's freedom of expression. Melissa said that she doesn't understand why they removed trial by jury, but in terms of going far enough, it does reduce the costs so that people such as ordinary people who don't have access to finances to support that will be able to bring a claim and defend a claim in liber. Overall, we agree that it doesn't go far enough, and there are a number of reasons for this. The main aim of the bill is to strike a balance between freedom of expression of the defendant and the freedom from having negative things said about you which could ruin your reputation. But by shifting the favour of the defendant, it doesn't actually do that. Nowhere in the bill does it define things like substantial or serious harm, so it still leaves a lot of power in the courts to interpret, and this can open up a lot of inconsistencies in the application of the law. Lord Hoffman said that libel tourism was more a myth than reality, and in 2009 it was proven that out of 219 defamation cases, only 34 had foreign connection. So some people argue that it's a myth and it doesn't actually exist. So even though the bill does attempt to address these issues, it doesn't exist to the extent which it's argued. It replaces justification with truth, but both require statements made to be substantially true, so it doesn't actually change that much. Overall, there are a number of changes such as removing trial by jury and requirement of serious harm, but in terms of striking a balance between freedom of expression and the right not to have negative things said about you, it doesn't actually go far enough in doing that.
Okay, good. Thank you very much, Carl.